What's up, everybody? It's Monday. We're back. A long weekend off. Hope everybody had a great Thanksgiving, a great holiday weekend, some time to rest, relax, maybe shop a little. Cyber Monday, maybe you're still shopping. Watch some football, some games that took some years off my life, at least on Saturday night, and probably another coming this Saturday as Florida State plays Louisville in the ACC championship. I hope you guys all had just a beautiful time and a wonderful time. A lot was going on when it comes to the Take Care of Maya case. So many of you reached out to me and sent me stuff about this, which is um, a wild motion to say the least. But I really, really think there is a very important question we need to talk about, and that is how YouTube and social media affected this case and how it's going to, I'm not going to say how may it, but how it is going to affect cases in the future. And I'm glad this happened now for us to have this discussion so we can see what's there, if anything, that a judge is going to need to consider when discussing a motion for new trial, a motion for mistrial, dealing with juror misconduct, dealing with jurors potentially seeing things or even searching things out during trial. How do we deal with that? What's the standard? What's going to happen now and in the future? And we're going to read through this motion for new trial based on juror misconduct. I'm going to read it a little bit differently, probably, than if you've listened to it on other shows. I want to read part of Ethan Shapiro, one of the defense attorneys. I'm going to read part of his affidavit instead of how they set it out in the motion. Then I want to look at the actual posts themselves that are exhibits so that we're not taking a lawyer's explanation for it necessarily, but we can see what those posts actually say, and how they could have or would have or did or did not affect the case. And then we're going to look through the legal standard and we're going to see how it's applied in Florida, how you would get a new trial in Florida, whether or not we think there should be a juror interview granted, whether or not we think there's enough here for a new trial. And I'll just say, a lot of these people are good people involved. Whether it's a YouTuber, whether it's a lawyer, whether it's a client, whether it's the judge, whatever it may be. So none of this is personal. I'm going to look at this and try to see it from both sides. And if I was a lawyer for Johns Hopkins, if I was the plaintiff's lawyer, whatever it may be, how I would use the facts in this case, apply the law, and make these arguments. And we might not agree on how we see all this. And I think that's important to understand as we go in. I know I say it all the time, but a lot of people feel very strongly about the outcome of this case. And I think, as we listen to the evidence, the verdict was pretty much what I expected, and I agreed with it for the most part, but the rules need to be followed. And I'm going to read through this and see if I think the rules were followed. And if they weren't, what is the remedy? That's the really important part to me. And I think that we really need to make sure that we take a deep breath, we read through it, we try to understand it objectively and see whether or not this rose to the level of juror misconduct, what they can prove, what's necessary. Are there still some unanswered questions? And do we have to wait until those questions are answered before we can have a really good hold on this? Just is. Can't tell what this is. Is that like a Christmas tree or something? I can't tell. But thank you for the super chat. And Cheryl, you as well. And the new members, Rusty Neo and Linda O. Welcome, welcome. If you guys have not subscribed to the channel, please take a second and subscribe. Give that video a like as well, so that if anybody else wants to come and talk about this, they can know that this is happening right now. And we are so close to 300,000 subscribers. We're less than 5,000 subs away. So let's talk about this. Starting with this affidavit of Ethan Shapiro. Okay. So they put a lot of this in the motion. When they give the factual background, we're just going to read at least part of this to see what Ethan Shapiro says, which is the facts that the defense found, where they found them, what they mean. And we're really going to dig in because there are a few major questions I have that I'm going to ask you and I'm going to want your opinion and take on. There are some things I feel pretty confident in the way it should go down. And then there are some overarching themes that we found through the trial and the jury's verdict that I think should outweigh any arguments made in this motion. So we're going to kind of take all that in part. But first, what does Mr. Shapiro have to say? He has personal knowledge of the facts described in this affidavit. We know that. He incorporates all this by reference, all the exhibits that we're going to look at later. Paul L. was juror number 1 and was the foreman of the jury in this trial. During the trial, Mr. Lengel, is that how you say it? We'll say Lengel. Mr. Lengel was apparently married to Yolanda Lengel. Throughout the trial, Mrs. Lengel heavily and consistently engaged in public commentary on this case through her YouTube username @HippoLover. Over the course of several weeks during the trial, Ms. Lengel posted at least 81 known comments to YouTube channels streaming this trial, such as Recovery Addict, Law and Lumber, and Lawyer You Know. Her comments largely consisted of sharing her opinions, which were biased in favor of the plaintiff. In addition, she shared information about the case that could only have been obtained through direct communications with juror number 1. So we're going to see issues throughout this, okay? We're going to see some things that we agree with. We're going to see some things that we don't agree with. And when I see that they say she has a bias toward the plaintiffs, well, every single person, including the thousands, tens of thousands, hundreds of thousands, maybe even millions of people watching this case that felt like Maya proved her case and ended up winning this case, getting the jury's verdict, getting a number that they felt was fair. Does that make you biased toward the plaintiff? If you think the plaintiff won, if you think they should have won, if you think that they should have prevailed in this case, does that make you biased toward the plaintiff? I would say that just means the plaintiff won. So all the jurors at this point, the defense would say, are biased toward the plaintiff, which to me is not the appropriate usage of that word. I see people having comments about the jurors' names. The jurors' names are public. They're in all these public filings. There's nothing inappropriate about reading the jurors' names at this point. So I understand if people are upset about that. I understand, but that's how it works in Florida. For example, during the live stream coverage of Detective Stephanie Graham's cross-examination on October 20th, 2023, Ms. Lengel posted the following comment: the juror LEO will be asking questions. So there's a number of ways we can interpret this. Number 1, the juror spoke to her husband, and her husband told her he's going to be asking questions. I think that's kind of impossible for her to do while the trial is going on, while juror number 1 is sitting in court. I don't know how he would tell his wife that he's going to ask questions. Or maybe she just knows her husband and knows that he's going to ask questions. I don't know. But let's also remember, everything they say about Mrs. Lengel does not necessarily attribute it to Mr. Lengel, who was the actual juror. So we need to make sure we keep that separate. For juror misconduct, that applies to the juror, not his wife or his kids or his friends. The day prior, she posted to the same YouTube channel, Detective Grant, LEO juror, LOL. Notably, Ms. Lengel sought out and developed a relationship with Jules, who served as plaintiff's online public advocate on platforms such as TikTok and YouTube. They exchanged messages online, personal phone numbers, made plans to meet, and can even be seen speaking to one another while Ms. Lengel physically attended trial on October 30th, 2023, where Ms. Lengel's husband was impaneled as a juror. Both Mrs. Lengel and juror number 1 knew one another, were present in the courtroom that day. Okay, so here's where some of the actual issues start to develop, because her comments online, which we're going to read through, whether or not those apply is kind of shaky, because again, it goes more towards her thoughts than juror number 1's thoughts. But showing up to trial with Jules, who we're going to read later, has had a lot of interaction with the plaintiffs, pictures of the plaintiffs, talking with the plaintiffs, things like that. I don't necessarily know that that she was the plaintiff's advocate. They make it seem like she was an agent of the plaintiff's lawyers, which I don't know that to be the case. I don't know these people personally, so it's hard for me to know, who worked for the plaintiff, who didn't. But from everything I know, I do not think Jules was an agent of the plaintiff. Okay, so we'll start with that. So when we have a situation where they state facts as if they are facts and they're not, they start to lose some credibility. And that's a problem. But if, okay, so I guess Jules is in the chat. Is this the Jules? Hello, Jules. So it said that is not true. Okay, so that's obviously an issue when they make it seem like she's an agent and a public advocate and she's not. Okay. However, there are pictures of Jules with the plaintiff, her family, things like that. I believe they were after trial. And then there are exhibits attached here of Jules talking to Ms. Lengel and also Jules talking to the plaintiff. So if the defense can show that there was an effect on juror number 1 throughout this process, then they may have something to work with as they move forward. And so we're going to look at the ways that they could potentially have an effect on juror number 1. So number 1 is the comments made by his wife, which we're going to see a lot more of those. Number 2 is if he knew Jules's relationship with the plaintiff, saw his wife and Jules together in court, and acted a certain way, either with questions, with his verdict, with his conversations with other jurors, because of that, then they could have something there. But one of the questions we just absolutely do not know the answer to is, what did juror number 1 know? What did he know at the time? Who were these people? Was there any involvement? Or was he just doing his job knowing that his wife was there? Okay, so here's another interesting tidbit here. Assuming this is the real Jules, okay? I'm sorry if I'm not, no disrespect, Jules. I probably is you. But I just, I don't know that personally. So Jules said she did not know who the lady was at the time, Mrs. Lengel. She did not disclose who she was. So these are things. This is pretty interesting, Jules. Thank you for sharing this with us. These are things the defense doesn't know. And once again, when they make factual statements like Jules and Mrs. Lengel were together, I know people are saying it is Jules. Okay, well, we'll go with this is Jules. And I don't mean any disrespect by that. I hope that you don't take any disrespect by me saying it probably is Jules. I have to be careful with what's going on. And again, we're going to continue to talk about how YouTube is affecting all of this. But if Jules didn't know that Mrs. Lengel was the wife of juror number 1, first. Number 2, if juror number 1 did not know who Jules was, which I think is very possible, if not even plausible, then how would this have an effect on juror number 1? Because if there was no connection made or known, then I think it's pretty hard to show juror misconduct. Now, if they did know who Jules was and Ms. Lengel sought her out because of Jules's advocacy, and again, all of this is tough, right? Because we're talking about somebody that we really feel for and we think went through a lot. And I think she proved that during the trial, but rules are still rules and have to be abided by. And so if there was misconduct, then it should affect the outcome of this case. But was there really misconduct? So if nobody knew who anybody was and they were just talking in the courtroom, which I heard was kind of how it was every single day. A bunch of people were just talking to each other in the courtroom and were there for a number of different reasons. So we'll continue to read. Notably, Ms. Lengel sought out. So again, it doesn't seem like they're putting the blame on Jules here. It seems like they're saying juror number 1's wife sought out Jules. So why? Did Ms. Lengel know who Jules was or vice versa? We don't know the answers to that. Like I said, some unanswerable questions. Physically attended the trial. Ms. Lengel's relationship with Jules is most unsettling because of Jules's close involvement with the Kowalski family. Jules communicated regularly with the plaintiffs. Details shared publicly on her TikTok account, Blind Gossip. On October 9, 2023, Jules shared on TikTok that she gave Maya Kowalski her rosary beads that she had during her live testimony that day. On October 11th, Jules would again share this story on Recovery Addict YouTube channel covering the trial. She stated she texted with Maya Kowalski over the weekend, gave the rosary to her and Jack Kowalski for their testimonies, and asked plaintiffs to not object to the jury's question regarding her carrying a rosary because Maya had the rosary in her pocket. This demonstrates that Jules was more than just an innocent bystander, but an advocate for the plaintiff at trial and on several social media platforms, bringing trial-related content to thousands of viewers each day. So this is where you get into a sticky situation of being involved with counsel and watching and, reporting as far as out to social media platforms. And when we discuss how to handle these cases, and we have to be careful, we all really have to be careful about what we're doing because we don't want overturned jury verdicts. We don't want trials to happen twice. I am sure Jules does not want the trials to happen again. I am sure juror number 1 and his wife do not want the trial to happen again. And I am absolutely positive that Maya and her team do not want the trial to happen again. So those are very difficult situations when things are going public about the trial, which if you're just reporting and watching, that makes 100% sense. But then once you start talking to Maya, once you start talking to the lawyers on the case, you just have to be careful with everything that you say and every step that you make, because this stuff eventually comes out. This stuff eventually is going to be dug into because you have lawyers, you have investigators, you've got literally $250 million worth of reasons for people to really dig deep, on this. And so I'm not saying there's any wrongdoing on anyone's part here. I'm not saying there's any wrongdoing on anyone's part. So I don't want anybody to take it that way. I'm just saying how lawyers are going to look at this stuff, what they are going to use, and how they are going to use it. But we'll continue reading because I think if you stick around, some of the really overarching themes at the end, I think you're going to find interesting on how all this works. All right. Jules also took several pictures of the plaintiffs and trial team during the trial and can be seen in the center frame of photograph with plaintiffs and their counsel following the verdict. I don't see any issue, by the way, with talking to plaintiffs' counsel, talking to the plaintiffs. If they'll talk to you, there's no problem with you talking to them. I don't think there's any problem with you talking to them. And if you're sharing things that they know and are fine with you sharing, I think that's, and I'm not just talking about Jules, I'm talking about in any case. In any case, if lawyers or people involved are going to talk to you and they don't have any problem with you talking to the world about it, then I don't see any problem with that. And Jules is not a juror on this case. Okay. I don't know Jules personally, like I've said already a million times, but she's not a juror on this case. And the jurors were told over and over and over again not to consume any outside information, outside media, outside social media. Don't talk to your friends, don't talk to your family members. So what Jules is doing should have no effect on juror number 1 or any juror if they're following the rules. That's the really important part. That's the really important part in this situation. Because Greg Anderson was giving interviews, right? Tons of national news media were talking about the case. Reporters were inside the courtroom. Lawyers were talking about the case. So why can't Jules take a picture? Why can't she talk about the case? Why can't she talk to plaintiff's counsel and the plaintiff? Right? Jules is not a juror. And I think that's important. And when the defense wants to talk about these connections being made and how closely related all these people are, there's a lot about Jules and there's a lot about Mrs. Lengel. But I kind of want to focus on how much is actually there about juror number 1, Mr. Lengel, the person who was actually under the rules of the court, under the orders of the court. That's really important. That's going to be the really important kind of theme throughout this on how media and YouTube affects these trials. The court heard defendant's motion to disqualify juror number 1, which was premised on juror number 1 suspected bias and prejudice in favor of the plaintiffs. While plaintiff's counsel Greg Anderson initially agreed to substitute juror number 1, which, by the way, if Greg Anderson was fine substituting out juror number 1, I don't think Greg Anderson and his advocate were really in on this plan to have some runaway jury, right? I mean, that's a pretty bad job by them if that was the plan they've concocted this whole time. So I don't see that personally. Um, let's see here. Mr. Anderson changed his position after consulting with Mr. Kowalski, stating that his client feels more comfortable with juror number one. After the court denied the motion, Mr. Kowalski can be seen turning to Jules, who was sitting behind him, and nodding his head with a smile. This inferentially demonstrates that relationship between Mrs. Langville and Jules was far more involved than just an innocent friendship, and establishes a reasonable belief that the information relayed by Mrs. Langville to Jules about her husband's seat on the jury was also relayed to Mr. Kowalski, a party to this trial. So, if this is true, okay, so let's just take this for what it is. If this is true, then I think that is an issue. If, and again, with Jules being in the chat, I'm sure she has a position on all of this and could say whether it's true or not. I'm not saying it is true. What I'm saying is, if it is true, it could be problematic. If there was some concoction between juror number one, juror number one's wife, Jules, and the plaintiffs, that's a problem. You can't do that. But the defense attorneys are making huge leaps in their statements, making factual allegations without knowing the whole story and being able to connect these dots. So again, here is another unanswerable question as to where we are. What is actually true? What are those conversations? And we're going to talk about more about how we get that answer. On October 31st, the day after attending the trial with Jules, Ms. Langel posted a comment regarding the jury's thoughts and opinions about Kathy Beatty, and the defendant's witnesses presented the day prior stating they did not like her. They did not like any of them. Obviously, Mrs. Langel's information regarding what they, the jury, did not like could only have come from juror number one himself. Okay, this is factually incorrect. It could not have only come from juror number one himself. We have people all the time talk about body language, going into courtrooms, reading the jury, seeing how they feel, what facial expressions are they making, what things are they saying. And there's a lot of different ways to think that they, the jury, did not like a witness or a bunch of other witnesses. Okay? And again, when you say things like, the only way they could know this, you're making a factual statement that now I feel like I can disprove if I'm the plaintiff's lawyer. Similarly, during the second day of jury deliberations on November 8, 2023, Ms. Lengel paid money to super chat or comment regarding juror number one's frustrations with not being able to obtain a report by Christy Kirby, stating, I think the note yesterday was frustrated juror that cannot reach number agreement and it will take days. I don't even again, if she's talking to juror number one and juror number one is telling her that, people are telling me to read Jules's comment in the chat. I'm trying, I'm doing my best. I'm reading the document, so it's hard for me to read the comments at the same time I'm reading the documents. I'm doing my best. Okay. But if juror number one is talking to all these people, that's a problem. If juror number one is talking to all these people, that is a problem for juror number one. Okay. Number two, if I am just telling you my outsider's point of view, when we're reading that note, I don't think that's what the jury was saying. I think the jury was saying they wanted those numbers. Those numbers only affected certain counts. So basically what I'm saying is, if I'm reading this, I think juror number one's wife was wrong. I think juror number one's wife did not pull the question that the jury was actually asking. And what does that tell me? That tells me that juror number one's wife was watching it just like us, right? And so she's coming to a conclusion of what she thinks a question means. And I disagree with her. I think the question means something else. And to me, that's a good sign for juror number one and his wife. Because if she is just reading these questions, she knows her husband, right? There's nothing wrong with knowing your husband. And she's saying things like, I think the question means this, but I'm sitting here thinking, I think the question means that. So to me, that's an indication that she is kind of guessing as she's watching and what she's seeing unfold in court, like the rest of us. Again, could be wrong, could be right. Other comments made by Mrs. Lengel during the trial include comments regarding research on the case, monitoring the court's docket, comments expressing bias in favor of the plaintiff and against the defense, expressing concern over the amount of time plaintiffs had remaining in the total allotted time by the court, sharing a photo of juror number one on the day they announced the verdict, showing him dressed up in a suit in preparation for the announcement of the verdict for post-verdict notoriety. So, besides the last one, D, juror number one's wife, Mrs. Lengel, is not prohibited from doing any of these things. The law does not prohibit a juror's wife or friend or daughter or son or mother or father from doing this kind of research. The court does not order. You can hear the court's order. The court does not say, jurors, go home and tell your family not to search anything on this case. The court does not say that. Court does not say that. On November 10th, following the verdict, Ms. Lengel immediately posted to a pro-plaintiff Facebook group named Take Care of Maya, where she thanked everyone who stuck up for juror number one, presumably referring to the defendant's motion to disqualify juror number one. The same day, juror number one posted a comment, that same group, suggesting that he was aware the defendant had moved to disqualify him as a juror. His comment stated, while the other jurors were escorted down to be transported, I was asked to remain by the SCSO lieutenant. Oh boy, I'm in trouble once again. But it was for just some security talk about that. Oops. Obviously, juror number one's knowledge of the disqualification motion indicates that he was communicating regarding the case with others, accessing information outside the trial, notwithstanding the court's instruction to the contrary. The motion to disqualify the juror number one would not have been known to him unless he were communicating outside the courtroom while others, inferentially his wife, Ms. Lengel. Okay, more issues with this paragraph. Number one, the same day, which is post-verdict, the same day, he was trying to be disqualified. And what he said is he was to remain there and he thought, oh boy, I'm in trouble. Where does it say that juror number one knew that he was being disqualified? Where does it say that juror number one knew about the motion for disqualification of juror number one? They're adding things in here as the defense that I do not think exist. And like I said, when you start to make these leaps, you lose credibility. Juror number one remained active in the Facebook group, liking comments suggesting he be careful regarding what he says to avoid overturning the verdict on appeal. So now all of this stuff, I believe, is post-verdict. A lot of people are saying Jules is innocent. Did somebody say Jules is guilty of something? It's hard for me to keep up with the chat. I am not accusing Jules of anything. I hope people are not accusing Jules of anything. There's a lot of questions coming through too. Okay. I will answer the questions. We've got a lot to get through. It's already been half an hour. Juror number one also began posting comments to the same YouTube channel that Ms. Lengel was active, paid $100 to Law and Lumber, happy to discuss the case with him. Rob, as a lawyer should, said he should consult with plaintiff's counsel before speaking publicly. And he said he agreed. Nothing wrong with that. Again, post-verdict, whether the guy gives an interview to Rob or ABC or Good Morning America, doesn't matter. It doesn't matter. Jurors are allowed to speak to lawyers. They're allowed to give interviews. They're allowed to do all that post-verdict. And everything I said about every other trial applies here. When we talked about it after, Rittenhouse trial, if we talked about it after Johnny Depp's trial, if we talk about it after Gwyneth Paltrow's trial, every single juror is allowed to give interviews. We always say knowing the truth is better than not. So why would we want them to be quiet if they're hiding something that's bad? Most of the time they're not. They give their honest opinion as to how they evaluated the case. And a lot of people are talking about the 144-page motion. We can talk about that kind of Cliff Notes version at the end if you guys want to, because a lot of this kind of applies to that as well, some of the overarching themes. All right. Juror number 1 said he was listening to counsel regarding the anticipated motion for new trial. Good. Nothing wrong with that. Is that supposed to be condemning? This comment suggests he spoke with plaintiff's counsel or his own counsel, who advised him defendant would be moving for new trial based on his misconduct. I could have told you that juror number 1 was going to be one of the reasons they asked for a new trial, because they tried to strike him near the end of trial. It's the absolute normal next step. There's nothing surprising about that. Juror number 1 seemed to enjoy his status as a hero amongst these pro plaintiffs platforms. I roll, like whatever, making posts in Facebook groups, super chat functions. For example, he asked Maya Kowalski about creature comforts, a term that was regularly used on Dr. Kilpatrick's RSD Foundation website, but never once brought up during the trial. I mean, again, a stretch, skipping steps to get to their conclusions. Taken together, the evidence herein establishes a reasonable belief that juror number 1 engaged in improper communications with Ms. Lengel during the trial and conducted outside research of the trial. Moreover, there is reason to believe that Ms. Lengel was sharing information obtained from juror number 1 to the public and plaintiff's public advocate and de facto agent Jules. Likewise, Ms. Lengel shared information obtained throughout the trial to juror number 1, who was under explicit instruction not to communicate research or anything about the trial of the case outside the evidence presented to them. So this is a true paragraph. Actually, I'm sorry. If this is a true paragraph, if juror number 1 did outside research, if juror number 1 obtained information and gave it to his wife, who gave it to Jules, who gave it to plaintiff's counsel, and plaintiff counsel used it during trial, if all of that happened, then that is misconduct by juror number 1. I don't think anybody in the chat should disagree with that. If that is what happened, then that is an issue. Okay. But that's a big if. And they do not have that information. I mean, Jules is saying she didn't even know it was a juror's wife. So how could this chain of custody of information be passed if they didn't even know it existed? In addition, it appears based on public court records that Deborah Salisbury, and this is another important question that's very strange to me. Deborah Salisbury, who is the attorney representing Jack Kowalski in the underlying DCF proceedings, and who served as a witness in the case and appeared heavily in the Netflix documentary Take Care of Maya, was an attorney involved in Mrs. Lengel's 2007 domestic relations proceedings. That is a bit of a side-eye moment for me. I don't know if, 2007 was a long time ago, 16 years ago. I don't know if she even remembered who Mrs. Salisbury was. I don't know juror number 1's involvement in Mrs. Lengel's 2007 domestic relations proceeding. So there's, again, so much we don't know. But the problem with it is this was not disclosed in juror number 1's questionnaire. Juror number 1 denied ever seeing the Take Care of Maya documentary. Well, do we know that that's not true? That might be true, but he did check the box that he does not know Deborah Salisbury. So if he does, then that's problematic. But I will remind you about the Ghislaine Maxwell juror. How some major things were answered just dead wrong on his jury questionnaire. He was brought in by the court and questioned after given immunity and having to hire a lawyer himself, admitted that those things were wrong, but didn't affect the case, didn't affect his verdict. And guess what? They did not overturn that verdict. So while this is a potential problem, it will not necessarily overturn the verdict. This is going much slower than I expected. But with an active chat, sometimes that happens. All right, I want to jump kind of towards the end here because a lot of that is like all of her comments that we're going to read in the exhibits. On November 10, 2023, juror number 1 and his wife posted to the Facebook group, Take Care of Maya, which is a plaintiff-favored internet community. The comments of juror number 1 and his wife, which were posted at various times on and after 11:10, are depicted in Exhibit B. He also joined the Law and Lumber YouTube live stream, commented they were happy to discuss the okay, we already read that. The host referred to juror number 1 to plaintiff's attorneys. Okay, we already read that. November 15th, he joined Law and Lumber live stream, which hosted plaintiff's expert, Dr. Joe Corcoran. Dr. Corcoran spoke about his view that the video of the then current CEO and then interim CEO of Johns Hopkins Hospital should not have been excluded in the punitive damages phase. And that if it had not, you can ask juror number one, that would have put another 0 in the punitive damages. In response, juror number one commented it would have been 14 zeros. Okay. So what the defense is arguing here is that juror number one, when making the verdict, didn't know about that video of Johns Hopkins CEO, right? He didn't know about it. It didn't affect his verdict, and it would have affected their verdict. And guess what? That was the point of the video. Plaintiff's lawyers were trying to get it to affect the verdict, to punish the hospital, which is the point of punitive damages. He didn't know that existed and said if he would have known, it would have changed their verdict. Duh. That's the point. So I think this totally counteracts a lot of the defense's arguments here. On November 19th, juror number one posted that he spoke to plaintiff's counsel and anticipated defendant's motion for new trial serves as the basis of the affidavit. Foregoing facts demonstrate juror number one violated the court's instruction by impermissibly sharing information about the trial with his wife. Again, they have no evidence of that. And undermine the confidence and integrity of the jury. Okay, that's Ethan Shapiro. All right, the next thing we're going to bring up here is going to be some of the comments, but let me answer some questions first. Anne Marie Perry, is this concerning the obviously biased juror number one? So I think his wife is heavily in favor of Maya, but is he? That is a question we don't know the answer to. And I mean, we do know the answer. He said he wasn't in jury selection. The defense had the opportunity to strike him. They didn't. And he got on this juror. They had tons of people to pick from. And he was one of the ones they picked from that they did not strike, and they had the opportunity to strike him. Maria, congrats, Peter, on the FSU win and remaining undefeated from a Gator fan. Good luck this Saturday. Thanks. We're going to need it. Bobby C., thank you so much for the gifted memberships. 5 new people have joined. Anne Marie, have you been contacted by the defense team? No, I have not been contacted by any team, defense or plaintiff. And if I was contacted by any team, just so you know, okay, just so you know, I would say the same thing. I would tell everybody the same thing. I just look at this and I say it, call it how I see it, as the phrase is used. There could be major issues here. But in these affidavits and these motions, they don't have the evidence necessary to get over the hump, which we're going to talk about if we ever get there. John, you seriously preach this to all your members. If you are connected to a case, stay offline, or her husband should have mentioned that in jury selection. Hard truth. I think that you can go online. It's possible. You just have to be careful. You have to be careful because you don't want to affect the verdict. And her husband should absolutely not be online and doing any of this because it would be violating a court order. But there's no evidence that he was. This reminds me of the Johnny Depp, thank you, Corinna, and Amber Heard situation. Patrick, thanks for gifting a membership. Where the defense lawyers basically said, come on, judge. Are we really supposed to believe that none of these jurors saw any of the memes or any of the TikToks or any of the things posted online about this case? That's impossible, judge. If they have a computer, if they have a phone, they obviously saw something. Well, guess what? That's not good enough to overturn a verdict. You have to have more than that. You have to have actual evidence of rules being broken, because the jury system is a bit of an honor system. And if these jurors say they didn't look at anything, they didn't do any research, they didn't talk to their family about it, why would we tell them not to if it was impossible? Why would that be in the rules? If it was impossible to not talk about this with your family, then we would say, sequester your family, don't let them look at anything, and you can go ahead and talk to them about it. But it's not. It's very possible and plausible that jurors do not talk to their family members about this stuff. Tom, Nicole, Complex Lit, Azam, John, Rebecca, Netwoman, Lady Law, Future, to name a few. Couldn't list them all. Kind, active, thoughtful, awesome community. I'm truly amazed. Thank you, Tom, and you're a big part of it as well. And John said, happy holidays to you, my friend. Patrick, Sorry I'm late, fam. YouTube literally just notified me of the live. Hope everyone had a great Thanksgiving. Thank you. Elmer, how can they even prove juror number one got any information from Jules and have his decision influenced based on that? That is a great question, Elmer. And guess what? The only way they could find out this information is with a juror interview. So the real question is, did they provide enough information to warrant a juror interview? This is not something we do lightly. The Florida Supreme Court, the U.S. Supreme Court, they do not want to put added pressure or outside influence or pressure on jurors, knowing that this is a possibility they could get interviewed and potentially get in trouble for something they inadvertently did during trial. So they do not love to grant juror interviews, but there are certain circumstances in which it is appropriate. And we'll talk about that when we get to the standard, the legal standard. Anne-Marie, why was his wife at the trial? Obviously, he was discussing the case with her at home. No one wanted to accept the obvious truth about juror number one. I don't know that this is true. You say obviously, but I don't know that it was obvious. And to my knowledge, there's nothing in the rules that says a juror's wife can't come and sit at trial. Now, if the court would have found out about it, would he have asked her to leave? Potentially. He probably would have had a little colloquy or had a discussion with juror number one about it. Was he talking to his wife? My guess is he knew the rules and, would not have talked to his wife and told the court he didn't talk to his wife. But again, a lot of us are just guessing at this point. I'll just say, I know I'm guessing. Anna P. Sorry if this is off topic, but I rarely catch you live. Can you break down the X Corp lawsuit with Media Matters? I've tried reading the filing, but I'm not sure what the accusation is. I will try to look at it. American Nana. Oh my gosh, I don't know how to super chat or chat. Lawyer, please let's follow me. No, Jules is not androids to juror number one. I'm sorry. Oh, okay. Trying again. All right. American Nana. Try again. Lawyer, please let chat. Jules is not married to juror number one. No, Jules is not Mrs. Lengel. If that was not obvious, I apologize. Jules is not married to juror number one. And Jules said, I do not know juror number one before, during, or after. So, we are having the benefit of Jules answering some of these questions. The defense may not know these answers yet. And that's why if a potential hearing happens, Jules can tell the court, I have no idea who these people are. She was sitting next to me. We talked online. I didn't even know, again, now I'm just putting words in Jules' mouth because there's, all sorts of scenarios. Maybe Jules is like, I didn't even know Hippo, whatever, was the person I met in court. That's possible. We don't know who everybody is based on their screen names, right? Shiraz, what is so unbelievable about couples who honor their oath not to discuss their work, case, patient, etc.? I agree. It can't be unbelievable, or else it's not possible for any juror ever. And we expect and believe it about every juror in every trial. Husband during jury selection should have stated his wife was a cyber warrior. I don't agree, John, which wouldn't be the first time we don't agree. A lot of times they'll ask what your spouse's occupation is. I don't know. Sometimes they'll ask, and again, I didn't see jury selection, so I don't ask. I don't know. I would have asked if anybody in your family had watched the Taking Care of Maya documentary and things like that. I would have asked that. I don't know if they did. Big Irish Jim. People need to stop using bias incorrectly. If juror number one or his wife or anyone else formed an opinion against J. Hatch after evidence, that's not bias. Correct. Anne-Marie, do you believe these accusations will prompt a hearing at the very least? Well, Anne-Marie, let's take this question and jump into the legal standard in that motion. Shiraz, thank you for gifting these memberships. All right. The legal standard for a new trial or interviewing a juror. This one's going fast and furious here. I do have a little bit more than an hour today, so I'm going to get through as much as I can, including the renewed DV. If we don't get through all of it, we can talk about it tomorrow. All right, legal standard. In support of a motion for new trial, Florida Rule Civil Procedure 1.431H permits a party to move for a juror interview if the party believes that grounds for legal challenge to a verdict may exist. An interview of a juror is proper where there is reasonable basis to believe that a prejudicial act occurred supporting a legal basis for a new trial, such as improper contact with a juror or misconduct of a juror. Thank you, Kat, for gifting more memberships. 10 of them. A party moving for a juror interview does not have to conclusively establish that the alleged incident occurred and actually prejudice his case, because a lot of times they can't prove that without the juror interview. Instead, it's only necessary to establish a basis for an inquiry. In contrast to what is needed to prove entitlement to a new juror, a party seeking only a juror interview must set forth sworn factual allegations that, if true, would require a trial court to order a new trial. In this regard, a party should be allowed the opportunity to prove that he is entitled to a juror interview. So that's the point of the sworn affidavit. Contact with a juror during trial about the pending matter, as the defendant believes occurred in this case, constitutes presumptively prejudicial juror misconduct. Once an improper conduct has been established, the burden then shifts to the party seeking to preserve the jury's verdict to demonstrate that the conduct was harmless. So once you show that there's enough there to grant a juror interview, then, thank you, Michelle, then the plaintiff has to prove after the juror interview that it was harmless, right? So once they prove that there's presumptively prejudicial information or juror misconduct, then the burden shifts to you to prove that it wasn't really a big deal, basically. Jules said, I exchanged numbers with lots of people. And so what? Oh, I'm sure Jules talked to lots of people with different screen names as well, right? I assume that was the case as well. Lady Law, thank you for this. And Donna Cole, gifting a membership. In this regard, once improper contact or juror misconduct is established by a juror interview, the moving party is then entitled to a new trial unless the opposing party can demonstrate there's no reasonable possibility that the juror misconduct affected the verdict. Okay? So here is our legal standard. Let me read you something else that we have used in the past. This is the criminal rule, Florida Rule of Criminal Procedure 3.600B, which are grounds for granting if prejudice is established. And this is grounds for a new trial. The court shall grant a new trial if substantial rights of the defendant were prejudiced because, and this is paragraphs 2, 3, and 4 under B. Number 2, the jury received any evidence out of court other than that resulting from an authorized view of the premises. Number 3, the juror, after retiring to deliberate upon the verdict, separated without leave of court. Or number 4, any juror was guilty of misconduct. So that's the rule of criminal procedure, which again, we have used sometimes, and we've seen this used in motions for new trial based on juror misconduct. So if the affidavit, if the exhibits go far enough to show that if they're true, they would create a situation for a mistrial, then potentially we need a juror interview. Which, to answer that question at this point, I do think it would be reasonable for Judge Carroll to grant a juror interview, to let the defense ask juror number 1, what did you know? Who did you talk to? Did you do any research? Because we're going to look through some of these comments now. We're going to go through some of the exhibits where juror number 1's wife, who was not a juror, I think that's important to keep reiterating, she was not a juror, but she posted that she was looking up stuff. She was obviously watching Recovery Addict and Law and Lumber while they were live streaming the trial. She was even apparently watching this channel. We didn't live stream the trial besides the verdict, I don't think, but even recaps or whatever. So she was getting outside information. There is nothing improper about that. There's no order. There's no rule. There's no law that says she can't do that. But was juror number 1 also doing it? Obviously, he wasn't watching the live streams because he was in court at the time. But was he gathering extraneous information that was outside the courtroom? If the answer to that is yes, that is enough for a new trial, in my opinion. But we do not know that to be the truth. And that's the big question here. And that's why I think potentially there is enough here to get a juror interview. But if juror number 1 comes in and says, I didn't look anything up, I didn't talk to my wife about the case, I saw she came to the courthouse that one day, but whether she was watching it on live stream or sitting in court didn't make a difference. She was watching. She knew we couldn't talk about it till after, and we didn't talk about it till after. And nothing she did, nothing Jules did. I didn't talk to Jules throughout the trial. I didn't talk to plaintiff's counsel throughout the trial. Nothing any of them did besides presenting evidence in court and making arguments affected my verdict at all. I did not come into this case biased in favor of Maya Kowalski. If those are his answers, it's over. There's no juror misconduct. There's no bias. There's no issue. There's no new trial. And more on that a little later. Let's take a second and jump now to, do I want to read any of this here? If you guys have questions about the legal standard, we can come back to that. I'm going to pull up now the exhibits that have a bunch of her posts here. All right, so this is a bunch of juror number one's posts. She was in the trial. That's her, and I believe Jules, and that's juror number one. Okay, so that's proof she was there. This is her Hippo Lover handle. And here are some of her comments. The juror LEO will be asking questions. Again, how could she ever know that? Well, a lot of people came to know that once juror number one was asking tons of questions. And just knowing her husband, that would be like my wife saying, the lawyer juror is going to have questions. It's like, yeah, if you know me, you're going to know I'm going to have questions. It's not rocket science. Let's get to some more of just her comments. Yesterday, I was frustrated. We already talked about that one. They did not like her. They did not like any of them. Again, I think, now again, if there's an interview and the juror says, yes, I went home and I told my wife that we didn't like her and we didn't like any of them, then that's problematic. But this does not say that. She never says in anything that I read, my husband told me this. Deposition today at 4 in Tampa regarding JC documents. We all knew that because they said it in open court. Sarasota County Clerk, the DV motion by the defendants basically said that if the judge granted it, no appellate court. Again, that's public record. Interesting motion filed about the DV yesterday. Carol versus Carol about Judge Carol's mom, about the judge when he was 16. Okay, I don't even know what that means, but I'm assuming that's all public. I think Sally Smith only relied on the Tampa General to decide, discounting all the others. That's literally cross-examination. Mr. Anderson was like, you didn't listen to this board-certified neurologist or pain doc, things like that. Ms. Lengel comment about a question the jury should ask of Johanna Klink, ARNP. She was concerned about their shot clock. How does this show juror misconduct, number one? And B, if she was going to make sure that her husband railroaded this jury trial and made sure the jury was going to rule in favor of Maya and made sure it was going to be $250 million, why would she care about Anderson's shot clock? Why would she care if the plaintiffs ran out of time? If it was over before it begun, because that's what the defense is saying. It didn't matter what happened in this case because they weren't going to consider the evidence and arguments in this courtroom. Well, if that was true, why does a shot clock matter? Again, more time about the shot clock and then excited that they got more hours. Definitely seems like she wanted the plaintiffs to win, right? As a lot of people did online. So it really comes down to, where is the connection with juror number one? Okay, this is all Jules, public advocate, okay, but she is not married to juror number one. There's nothing against any of the stuff Jules did as far as the court rules go, that I know of, I should say, that's publicly available. More comments. I would love to schedule a sketch that someone made of the defense lawyers. There's this case on Google. Okay, we already saw that. It's a different phone call, not this one. It's a different voice than this one. Okay, this is her just kind of discussing whose voice is on the phone, just like literally hundreds of thousands of other people were commenting and thinking about. The more I listen, the more I think it's her voice. Regardless, win for plaintiff. So she's still, I mean, frankly, if we're just looking at her, she's still considering whether it's a win for the plaintiff or the defense, witness by witness. She seems frustrated that Anderson's burning time. I mean, she definitely does not seem like an agent of Mr. Anderson or Mr. Whitney at this point, right? I mean, she's just kind of typing how she's thinking. And she's looking at motions. There's no doubt she's looking at extra stuff outside the courtroom. No doubt about that, but she's allowed to. Thank you for covering this. You and Rob have empathy colds. Many of the people in the courtroom do. Texting about ketamine girl text, one sitting in court every day. So proud of Anderson. He was like a cat, no questions after, just pounce after the jury questions. Kudos. They said they should ask if she lied, LOL. I mean, can't wait for Jules's recap. So I guess she did know who Jules was. Prayers and hoping for the best. Recovery Addict is awesome. Law and Lumber, can't wait tonight. If plaintiff runs out of time, can the depositions be played? No. But I mean, those are all fair questions. Jules might call. By the way, I didn't see that she said that she was juror number one's wife in any of these comments. I could be wrong on that. Kathy is who put my on her lap. Jules, I can't wait to meet you tomorrow. Where can we get pumpkin pie whiskey? Again, nothing that says I'm juror number one's wife. Did they grant plaintiff more time? So again, asking questions. Doesn't seem like she's overly privy to things happening. Get rest. You coming back to court tomorrow? Can't take off work. Again, nothing to suggest she's juror number one's wife there, or especially that she spoke to juror number one about any of this. Jules just saying morning to multiple people, like Jules said. She got tons of numbers. I'm sure she met tons of people online. Talk about Ian's fundraiser. Why make the alternates sit through this? Again, how is he going to tell some of the jurors that they are alternates? You would think that she wouldn't need to ask some of these questions if her juror husband was telling her everything going on in the courtroom. No court Friday. This one will be making history in Florida. So she thought, but again, a lot of us said it was going to be a long deliberation. This is my hubby. Give him time to digest. And he said, being the day after, I'm taking period of review. So again, this is the day after. Lots of jurors give interviews in lots of cases. Every lawyer that's on the losing side is mad about it for the most part and is absolutely going to comb through those interviews to try to find something to overturn the verdict. That's what's going to happen. We've talked about this. And we've always said we would err on the side of, yes, jurors give interviews. We want to learn. We want to understand. We want to be educated. But jurors do need to know that what they say, jurors need to know they need to follow the rules, period. They need to know it before they ever go back there. And then when they come out and give interviews, they already know that. They already should have abided by the rules, so there shouldn't be a problem. And he says right here, I'm quite shocked at all the fuss about juror number one. I just followed the initial juror instructions, took 12 pads of notes, I write big, asked questions to understand or inquire, then 6 had equal say in the deliberations, reviewed our notes, evidence binders, and bam, done. Also, those that have sent me requests, I'm not ignoring you by no means. I'm just taking a spell before I address them. So keep coming. Keep them coming. So that seems to be our answer. I followed the initial juror instructions. And if that in fact is what he would say in a juror interview, I do not expect any of this to lead to a new trial. It's as simple as that. He may have to answer questions in a juror interview. But if these are the answers he gives, we can't just say, oh, you're lying. She's your wife. She was looking up stuff. We need a new trial. That's not how it works. Or else lawyers could literally say that about every single jury in every single case. He loved some comments that said it's entirely online as well. We've all been doing it. It really doesn't make any difference if a juror, spouse, or the entire family decided to sit in the courtroom as long as they didn't discuss it. I think it's probably not the best to sit in the courtroom, but yeah, I don't think there's any rules against it. There's also potentially, I say potentially, as I don't know if it is or isn't evidence that the wife of number one was in court for a whole day and was chatting with Jules. Jules asking if wife was going to be in court the next day. Again, I don't think there was anything that said Jules knew that was her wife, and Jules said today she didn't know that it was juror number one's wife. If the above is true, I suspect that may well be a problem in the verdict. And we have this Judge Carroll meme. While the other jurors were escorted down the transcript, I was asked to remain, but it was just sort of security talk about that. Oops. All in all, I'm happy. So yes, I'm juror number one. And again, anybody that has a problem, he is publicly displaying he's juror number one with his name. So yes, I'm juror number one. I was the first to check in that day for the selection process. I was then the last juror to check out. So if he was literally juror number one of the entire panel, do you know how unlikely it is for juror number one to make it on the panel? It's more likely that jurors later on down the line, because we won't run out of strikes as lawyers, make it on the panel. So the fact that he was juror number one and made it on the panel probably means he made it through the process pretty cleanly. Former law enforcement, no major issues. They both thought he could be fair and unbiased when they chose him, because they did choose him by choosing not to strike him. The case is by no means over. Defense is going to file something. We're listening to counsel as it ain't over. You are correct. The MKJH that us 12, then 6 jurors deliberated, all with equal input. That phase is over. The next phase is the defense filing their appeal. An appeal is usually always the following step and is not unique. Agree. Everybody knows that, not just him. He could have watched a million YouTube channels that said that. Juror number one was there in Rob's chat, which we already know, and Dr. Corcoran, and a bunch of zeros, which we already know. They follow a bunch of people on Twitter that discuss this stuff. And here's him saying, so this is an interesting part to me. He says he did not know Deborah Salisbury. That is interesting. Could just be a mistake. Could be just his wife's lawyer that he didn't know. I don't know, but that could be interesting. Okay, a couple overarching themes here before I answer more questions, and then maybe we just briefly, ever so quickly, talk about an overview of that new renewed DV motion. It's 144 pages. Max Sauce. Hey, Peter and everyone. Hope you guys had a great Thanksgiving. You too, Max Sauce. Chronic Christie. That's a lot of ifs with very little actual evidence. Does this surprise you that the motion has little evidence? No, they have more than you have in a lot of cases with all these screenshots and conversations and pictures of people in court. And that's why I think potentially they will get a juror interview, but there's nothing here that is evidence as for a motion for new trial, in my opinion, unless juror number one's answers drastically change if he is sitting in an interview. Netwoman, in my opinion, I think Shapiro affected the penalty money when the plaintiff's side was presenting, and he interjected that the money would bankrupt the hospital. Peter, thanks for continuing with Maya. Netwoman, I don't think he affected it in a positive way, which I think is what you're saying. Victor, he was a cop. Couldn't talk about his day there. This might be an opportunity for his wife to see what he is going through. Potentially. Sherry, bottom line, defense thought juror number one would go in their favor because ex-law enforcement, they messed up in voir dire, and now they're soaking. This could very well be true. It would be interesting to see their notes. Did they heart or star juror number one like they really wanted him? Because that happens sometimes. Gingy Probs, happy Monday. Question: is this just a CYA, i.e., would it be considered poor representation if the defense didn't file something like this? No, I think they really think they have something here, and they have more than you have in your average case. Elin, wow, I have never seen your chat be this hostile. Great. Let's try to keep it respectful. We can disagree. We can disagree here and still be respectful. Azam, Peter, is it allowed for the attorneys to watch YouTube or other social media and use them as reference during the trial? Thanks, Peter, and go Knowles. Yes, go Knowles. No problem with the attorneys watching these videos. I would watch them. See what the public pulse is on the case. See what other lawyers are saying. I don't think there's anything wrong with lawyers watching these cases. I wouldn't reference them in the trial like, Rob from Law and Lumber said this. I probably wouldn't say that in court, but I mean, consuming media on it for the attorneys is not outside the rules. Energy, almost 6K people in the chat. Let's hit that like button, everybody. Yes. Hit the like button if you guys are still sticking around here. As we're in overtime already, we're past an hour. I like to cut it off at an hour. John, do Becky and Jules stand in similar positions? Seem similar, kind of? Absolutely not. They could not be in more different positions. Becky was in control. Becky is under very specific rules. Becky had a job to do, and Becky did a lot before, during, and after, at least allegedly. Jules, even if Jules did what she is accused of here, she could still maybe have done nothing wrong. If juror number one's wife talked to her and she talked to juror number one's wife and shared certain things juror number one's wife knew or said or whatever, if there was no discussions with juror number one, that might not be a problem. If Jules didn't know this was juror number one's wife, might not be a problem. If Jules was not relaying information as the plaintiff's agent back and forth to juror number one in this whole conspiracy, then no problem. Just because Jules was there talking about it online and talking about it with people in the gallery or talking with plaintiff's counsel about it doesn't mean she did anything wrong. We don't know all the facts here, but based on what we know, I would say Becky and Jules are in very, very different positions. Nikki, can the defense really ask for their phone records? Yes, they can ask. That's a pretty big invasion of privacy. I don't know that the judge would allow that. I probably wouldn't, but I probably would allow a juror interview. Netwoman, don't all 6 jurors have to be unanimous? None of these jurors have come forward and said, number one, force their verdict. Their verdicts were pretty fast, which is telling they believed Maya. Dang it, Netwoman. Dang it. So I was going to talk about a couple of my overarching themes here that may make all of this moot. And this is one of them. Here's the problem with the defense's position. Because as we read the standard, even after a juror interview, they have to prove that this substantially affected the verdict, and then the plaintiffs would have to then rebut it by saying, no, it didn't. Juror number one is one guy. And if he was this conspiracy theorist, runaway juror, forced his way on the jury to make sure Maya got $250 million, then what about the other 5 jurors? Not only do they all agree to a huge amount of damages, they chose juror number one to be the foreman. And they've heard in the weeks post-trial of what happened. They probably know about motions to disqualify and get rid of juror number one and misconduct. Have any of them come out and said, yup, he was talking to his wife. Yup, he was bringing us information we didn't know about from outside the courtroom. Yup, he was talking to Jules here and there. Yup, he did talk about the Take Care of Maya documentary or the Facebook page. No, none of that has come out. I guess it doesn't mean it doesn't exist, but at this point, if we're looking at what we know, it sure as heck feels really hard to think that this was all a big plan from juror number one to go in there and do something nefarious to make sure he got the verdict he wanted. Do you know what it seems like to me? It seems like a juror that listened to the evidence and got more and more pissed off about how Maya was treated by Johns Hopkins and hammered them at the end. A juror that believed, when we went through Maya's testimony, he believed Maya about the mental pain and anguish that she went through as a result of Johns Hopkins' actions. That's what this looks like to me. Like they said in the Adelson trial, sometimes the simplest explanation is true. And that, I think, is the simplest and probably truthful explanation. Thank you, Tiffany. Rain Man, J Hatch, this case was a tire fire for us. What do we put it out with? Also, J Hatch, gasoline and dirty diapers. Credit to Runkle of the Bailey. Tiffany, what would the court investigate and make the juror show his devices to the court and see what was actually doing while a juror, or would his word be took? So this is judicial discretion. The judge gets to make the decision. Again, all I could say is if I was the judge, based on the rules, I would allow the juror discussion. I would allow defense counsel to ask questions. And if during the questioning, either you felt like it was obvious, maybe there was something not truthful or inconsistent, and that would lead you to go get their phones or more information. But generally speaking, juror number one seems pretty competent. Seems like he's thought about this. Seems like he focused on sticking by the rules as he made in that Facebook post. And if all that's true and he stuck by the rules and did everything right and answers it that way in court, I think it's going to be over. Gringa, were jurors asked whether they watched the Netflix movie during jury selection? Yes. Now, I don't know which jurors said they did and which one didn't, but yes. Christy, Peter, does spousal privilege apply here? No, probably not in this situation. But there are ways, like if it waded into certain like criminal aspects or other things like that, it potentially could, but I don't think it would apply here. But we'll see. Maybe they'll get a lawyer and try to argue it. Azam, thank you so much for the gifted membership. And J. Michael RN, you as well. All right, another overarching theme and point. Thank you, KS Law Nerd, for 20 memberships. That's awesome. Is if juror number one was a runaway juror who went in there, a runaway juror, somebody who basically forces their way on to force the verdict they want and the amount of money they want. Well, he did a pretty horrible job of trying to hide it by asking all of those questions, by being kind of loud and out there and not flying under the radar, which most runaway jurors, I would think, once they got on the jury would fly under the radar. And then once the jury starts deliberating, really push for what they want. He did not do that. And then he came out afterwards and told everybody he was juror number one. So if he really was trying to hijack this situation, he didn't do a very good job of hiding it. And to me, that indicates he probably wasn't. And he feels proud about his jury service and about the verdict that he gave. And he does feel like he had a hand in justice. That's okay. That's the point of the civil justice system. The jurors get it right, and they should be proud of their verdict. They follow the law and the evidence, and they apply the evidence to the law. Aaron, opinion on the judge not letting the defense impeach Maya and her dad about the IV ketamine at home. I don't know. There was tons of arguments about that and tons of decisions made about the judge. I don't know the judge's reasoning or all of the facts around it, so I really can't comment on that. Thank you, Lisa S., for your super chats here. Okay, let's just take a look here at something on this motion for new trial and renew a lot of the arguments on the directed verdicts. Okay, I need a quick sip. My head's spinning a little. Oh, okay, this is a lot in an hour. I got about 10 minutes left. Thank you, Anne. So this is page 7. Let's jump to page. So this is the defendant's renewed motion for directed verdict, motion for new trial, and motion for remittitor. What this means is all the directed verdicts they lost, which was basically after all the evidence and arguments, no reasonable juror could find in favor of the plaintiff. Judge denied all of those, or I should say the vast majority of those, and all the ones the judge denied, they say you should overturn them. Then they have some reasons why they think there should be a new trial. And if they don't get a new trial, this is a motion for remittitor, which basically means reduce the amount of the verdict. And right when this happened, I did expect somewhat of a remittitor or fix on the verdict, which we'll talk about that. And the plaintiffs, I think, would even agree or have even agreed. But this is, if I'm a plaintiff's lawyer, this is a motion that makes me smile. And you may say, why would this make you smile as a plaintiff's lawyer if they're filing this motion to say, no, you shouldn't have won. You should lose. And here's all the reasons you should lose on appeal. Everybody's so scared of an appeal. Why would a plaintiff's lawyer like this? Let's talk about it. Emily is just happy to not be involved. It's only 144 pages, Emily. What's the big deal? Just 144. This is civil law. Welcome to civil law, because they get to bill for all 144 pages of work here. Probably multiple lawyers. And they're like, listen, insurance company or J Hatch, who's paying for this. It's like, listen, we only had a certain amount of time to get this done. We had to smash it in. We work 25 hours a day. All right. So why would I like this? Why would this make me smile? Let's take a look. A motion for new trial based on the manifest weight of the evidence, which we see over and over and over again. What does that mean? That means, Judge, there's no way that the evidence presented in this case could have let the plaintiff reach their burden of, by the greater weight of the evidence or clear and convincing evidence in certain circumstances. There's no way. No reasonable juror could ever come down in favor of the plaintiff. Now, here's the problem with that. 6 jurors that the defense thought was reasonable at the beginning of the case all decided unanimously in favor of the plaintiff. That's number one problem. Hundreds of thousands, if not millions, of potential jurors looking at this evidence and watching this trial also would come down in favor of Maya. So this is just an objectively losing argument that no reasonable juror could ever have found for Maya. So you can basically skip through all those, in my opinion. There's no way they win on all those. But here's my favorite part. A motion for new trial based on excessive awards of damages. And they say this over and over again. Look at excessive awards of damages. The court erred in allowing the plaintiff to make the massive request for damages. And then again, excessive compensatory damages, compensatory damages. They gave Maya way too much money. Anytime I see that, which I just did in my last trial, the appeal that's ongoing right now, the jury gave way more money than they ever should have or ever could be plausible or possible with this set of facts. And it's a tale as old as time that big companies, big corporations, insurance companies, a lot of defendants, a lot of defense attorneys, civil defense attorneys, they discount, they don't believe, they don't value non-economic damages, pain and suffering, mental anguish, the effect this has on people's lives that don't come in the form of lost wages and medical bills and expenses. They do not understand. They do not agree with. They've never seen a verdict that they agree with that has a decent amount of non-economic damages. And that is what they argue here. All they did was hold her down for a few minutes. All they did was take a picture of her in shorts and a sports bra to document injuries. All Miss Beatty did was put Maya on her lap and give her a few kisses. That's all they did. This is way too much money for that. As someone with a 10-year-old daughter, I disagree. I think it's not enough money. But what will a judge do? And what does the law say? The law says if it is excessive, the judge can, within their discretion, reduce it to a reasonable amount. At one point, the defense attorneys ask for it to be reduced to $300,000 would be fair. For one part, that was a multi-million-dollar part of the verdict. It's like, wouldn't that be nice? Except that, guess what? Even Mr. Shapiro was throwing out multi-million-dollar numbers as reasonable amounts for different portions of the verdict. And that's why I said during closing, if I was a defense attorney, I would never give on that. Now, I could be wrong and I could get hammered even worse, but I'm not going to tell him to give $4, $5, $6 million. Pass. And now it could come back to bite you when you file a motion like this saying they either shouldn't get anything or it should just be a couple $100,000. It's It's like, that's not what you said. And I always love when defense attorneys make the same arguments over and over again to a judge post-trial that they tried to make to a jury for days or weeks that a jury disregarded and disagreed with when weighing and comparing the evidence presented. This is literally trying to circumvent the jury system. Now, when I did say I did think that this verdict should get reduced, I think it could get reduced somewhat, but I think even if it was reduced, it would be reduced to an amount that the plaintiffs would still be happy with, over $100 million that the defense would still not be happy with. I don't think there's going to be any major remitter here. But where I do think there should be a reduction, and I kind of chuckled when it happened, that told us, this tells us everything we need to know about what this jury thinks about Johns Hopkins and what they think about Maya. When the dad's claim for fraudulent billing, when the plaintiff said, you can just give him $1 and we'll figure that out later, the jury's like, hold my beer. We're going to give him $5 million. Now, why that's kind of makes you chuckle and smile as a plaintiff's lawyer because you proved your case. The defense can and will use that as evidence that this jury was disregarding the evidence, and they actually gave more. I think they said they gave 105% of what the plaintiffs asked for. Now, they should know there's no rule that says a jury can't give more than the plaintiff asks for. But if the judge sees that as indicative that passion was, reigning over logic, and they just wanted to hammer Johns Hopkins, and that's, evidenced by this $5 million on the fraudulent billing, which I think even the plaintiff has agreed should be reduced to $1. I do think that could be problematic, but I don't actually see it being a problem. Secondarily, they say punitive damages were too high. I thought they were low. I expected them to be higher. I would be shocked if in a case where down the line, the jury found intentional quasi-criminal action on behalf of Johns Hopkins and their staff or agents, and a company worth over $1 billion was hit with $50 million in punitives, and that's going to be excessive. Highly doubtful. Highly doubtful. If anything gets reduced, I would expect it to be the compensatory damages, not the punitive damages. And I would actually have a problem with it. I know some people think, yeah, it should get reduced. This is too much money. I don't think people understand pain and suffering unless it's happening to them. And it seems like this jury did understand Maya and her family's pain and suffering. And that's why they hit them with this huge verdict. If they want to reduce some of the medical bills, like, hey, it actually isn't going to cost that much. The evidence showed that it wasn't going to cost $1.5 million. It was going to cost $900,000. Fine. Reduce it $600K. But I would have a problem with them reducing any of the non-economic damages because I think they proved those in this case. And I think we don't want people to go through this. And we need to make sure they don't. And that's what the civil justice system is for. All right. So if you guys want a more in-depth discussion of this 144-page document, let me know in the comments. I'm going to answer a few more questions here before I have to run. Judy, off topic. Can you please discuss the 2 writs of mandamus and the judge's response in the Delphi case at some point? I haven't seen them. If somebody wants to send them to me on Instagram or Twitter, I can take a look. Forever Wander. Are you doing okay? Being mentioned in all this. I couldn't care less. So somebody watched our YouTube channel. The way I run this YouTube channel, the way I talk on this, I'm okay. I try to make sure. Now, maybe I've, called people scumbags or whatever, or crossed the line or been kind of a jerk or whatever once or twice and tried to back it down when you guys hold me accountable, which I always appreciate. But I would be perfectly fine discussing everything I talk about on this channel with any judge or lawyer or party involved. I don't try to be disrespectful. It doesn't mean I always agree with you if you're a lawyer or a judge or even a witness, but I try to be respectful. I try to put myself in the lawyer's shoes. If I'm the defense attorney, this is what I would argue. If I'm the plaintiff's attorney, this is what I would argue. Would I have a problem with this? Would I have a problem with that? So I don't know that any judge watching this would be like, oh man, Mr. Tragos really violated a rule or said something he shouldn't have said. It's like, I'm looking at the case. I'm commenting on it. I'm breaking it down. I'm telling you what I think. I'm asking you guys questions. I'm telling parties, witnesses, jurors do not come and listen to this or any of this, or you tell the judge if you have, because you need to be off. Witnesses, if you're sequestered, don't watch any of this. If you do, tell the judge because you'll be off. And people involved in the trial, Watch with caution. That's it. Be careful. Make good decisions. Don't violate any of the court's orders. John, this action only hurts us, aka the public media forums. They will be removing access to the courtrooms, right? The public needs to stay quiet on social media if the public wants to have access to the records. Is that wrong? I don't agree with that. I think it can be problematic if it's misused. But I also think it could be a major benefit to the court system. And again, shine a light. And Hunter Carroll complimented how this was run throughout this trial. Because I don't think this is going away. I really don't. I think we need to use it the right way, like you said, and not as a tool to force an outcome or to put pressure on jurors or anybody like that. We should be seeking the truth and discussing it just like it's happening inside that courtroom, so that if they do watch this, not the jurors can't because there's stuff that doesn't come before them that sees it. But if like a judge were to watch this, that he wouldn't have a problem with what we're talking about on here. Ann Whitaker, to begin with, I was siding with the hospital until I listened to the evidence. I'm 100% with Maya. I mean, that happens. That happens. Azam, thanks so much for the overtime, Peter. Thanks, John, too. Thank you, Azam. Nirvana, as one of three mentioned, maybe charity. I don't know what that means. It's one of three mentioned, maybe charity. I don't know what that means. Sorry. Armchair apothecary. Sorry, I'm sure I'm saying that wrong. What's the story with the $1? Excuse my ignorance. So those are nominal damages if they could figure out exactly what he lost or paid in coverage, or his insurance company may have a right to go and recover some of that money. And the plaintiffs argued they needed a judgment that showed that they won on that and it was fraudulent billing to help his insurance go recoup some of that. It's complicated, but not a huge part of our discussion. DSN, thank you for the super sticker. Brandon, welcome to the crew. I am officially going to be late for my 3:30. Fiona, thank you for the super chat as well. Now listen, everybody. I appreciate, yes, John O'Rourke is absolutely entitled to his opinion. I appreciate his opinion. And I think there are a lot of people that agree with him and he might end up being right. So that's why I like discussing it. And that's why I love that he asks those questions. He's not afraid to be on the other side of a discussion. Neither am I. I think that's important, especially to be on the other side of the discussion of the person that's actually, got the microphone and talking. Like we had our members, our 4-person Zoom, and he's like, what do you think about being called a ambulance chaser? I was like, I appreciate that. Thank you for bringing it up. Let's talk about it. And we talked through it. That stuff is important. Those conversations should be had. Those questions should be asked because you're not the only one with them. All right. John is going to gift 5 memberships. Hope 5 people that are probably going to disagree with John, but still say thank you to him for the memberships. All right. I got to get out of here. You guys are so awesome. Let me know if you want me to break down more of that 144-page document. We can talk about it. Don't forget to subscribe. If everybody that watches this subscribed, that hasn't subscribed, my guess is we'll hit 300K. So please do that. You guys, Peter's mind isn't reading correctly. Oh, okay. So maybe I read it wrong. Sorry. All right. You guys are the best. I appreciate you. Until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.